Hello, my name is Brad Spinner, and I am here to review a case study for week 4. I chose case 7.13 off of page 252 in our textbook. This case is concerning Vernonia School District versus Acton. The plaintiff and defendant in this case, the plaintiff is Vernonia School District and the defendant is James Acton and his parents. The case was concerning compliance with random drug testing in order to participate in interscholastic athletics. The plaintiff claims that drug testing violates the 4th and 14th Amendments of the Constitution. The 4th and 14th Amendments of the Constitution kind of go hand in hand. The 4th Amendment protects citizens from illegal search and seizure and their right to privacy. The 14th Amendment expands upon the 4th Amendment by including the search and seizure by state officers, including public school officials. This case was heard first of all, and the lowest court, the first court that heard the case ruled in favor of the plaintiffs, Vernonia School District, and said that drug testing was constitutional. The Ninth Circuit of Appeals Court then heard the case, and they overturned the lower court's ruling and stated that drug testing did, in fact, violate the 4th and 14th Amendments. Then the case was given certiorari, which is an order or writ by which a higher court reviews the ruling of a lower court. In this case, the Supreme Court reviewed the ruling of the Ninth Circuit Court of Appeals, and some of the background information that led up to this lawsuit was that in Vernonia, Oregon, which was a small logging community that had 1 high school and 3 grade schools, had been relatively drug-free, no drug problems at all in the early to mid 80s. But then in 1988 and 1989, teachers and administrators noticed a sharp increase in drug use, and the amount of disciplinary referrals also sharply increased, and over more than doubling the number of referrals in those 2 years as opposed to earlier in the decade, in the early 80s. And a drug culture was established, and a lot of misunderstandings about drug use was prevalent in the schools. And it turned out that the athletes were the leaders of this drug culture. So Vernonia School District tried to come up with a solution. They initially tried bringing speakers to scare kids and offering classes to teach the dangers and educate kids on the dangers of drug use, but it ultimately was ineffective. So they then wanted to implement a drug testing policy for their athletes, but first they asked the parents, and the parents gave them overwhelming support. So they implemented their drug policy primarily for athletes, because they thought that because drugs reduce your motivation, your memory, your judgment, your reaction coordination, and performance, that they were seeing sports-related injuries increase because of drug use. And so to protect the athletes, to protect their student athletes, those not only using drugs, but those who weren't using drugs, to keep them safe, they implemented this drug policy. The drug policy that they laid out was very detailed, and every parent and athlete had to sign a consent form before they could participate in athletics. Some of the details they went into was not only were you tested, but if you were to test positive for drugs, then not only were you given a suspension, but you were also offered help to get better and to overcome drug abuse. They also laid out a very specific plan on how the drug or the urine sample would be taken. A chain of custody for the urine sample was set in place. A method of recognizing and noticing tampering of samples was set in place. Training was set in place. Very detailed about how these urine samples would be handled and administered. The lawsuit itself occurred in 1991 when James Acton, who was then a 7th grader, was denied participation in football because his parents refused to sign the consent form, claiming that the 4th and 14th Amendment and a person's right to privacy were being violated. They also argued that the test should be done only if there was a suspicion of drug use, and that drug testing all athletes was unreasonable. They also were concerned that a person's medical history would be in jeopardy and be public knowledge if drug testing was done. The court's response to it, the certiorari ruling from the Supreme Court, ruled that the school's administrators are in loco parentis, which meant that when a student was at school, the administrators and teachers of that school acted as temporary guardians of that student and had a responsibility to exercise the rights of a parent in protecting the children that were entrusted to them. So they ruled that the right of privacy. They also ruled that the right to privacy was not infringed upon because public restrooms, which is where the urine samples were going to be given, were not private places. Locker rooms and showers inherently, in an athletic setting, inherently lack privacy. And by volunteering to participate in athletics, the athlete should have a reduced expectation of privacy. So they ruled that the right to privacy was not infringed upon by drug testing. The court also ruled that drug testing was reasonable and that there was a compelling need for the program, meaning that the drug culture that had developed in this Vernonia School District was in need of immediate attention. And this drug testing policy was within reason, and there was a need for it. And so they ruled that it was necessary. And they also ruled that drug testing just those who were under suspicion wasn't reasonable because it fell outside of a teacher's and an administrator's already hectic responsibilities, and teachers were not able to take on that duty as well. They also felt that drug testing only those who were under suspicion would lead to bias, would lead to being drug tested as being a badge of shame when that was not meant to be the purpose of the drug testing. The drug testing was there to deter drug use, not to shame drug users. So, in conclusion, the Supreme Court ruled that Vernonia's policy on drug testing was reasonable and therefore it was constitutional. Now, what's that mean for us as athletic directors? Well, first and foremost, it means that drug testing is constitutional. But I also learned from this that if you're going to implement a drug test policy, that policy must be overly detailed. No detail is too small to include in that policy. And not only should the policy prevent drug use, but should also provide assistance for those that are abusing drugs. Thank you for listening.